To understand the structural problems with HB 620, look no further than today's case. Now here, two third parties successfully sought parental responsibilities of a child from both mom and dad. Now, parental responsibilities is a term Illinois uses for custody. And yes, under the statute, in rare situations, people who aren't the mom or dad can seek custody of a child. Now, I won't go into it here, but there's a link in the description below that will take you to a case where I do outline how that sometimes happens. Now here, the father contests this custody award by filing a motion to vacate, arguing that third parties should not be awarded parental responsibilities unless the parents are found unfit. That was something that wasn't indicated in the initial custody order. Now the judge agrees but amends the order to indicate mom and dad were unfit under the Adoption Act. Now keep in mind, this is not an adoption case, nor is it a guardianship case or a juvenile matter. It's parentage court, and neither parent was alleged to be unfit in the underlying petition seeking third-party allocation. Dad appeals, arguing you can't do it like this. The appellate court, they agree, at least in part, and this is where things get a little bit murky. The court agrees the judge was within his powers to allow the child to be placed in the custody of third parties, but a finding of unfitness is not required for that to happen. However, the court doesn't stop there and kind of opines on whether a judge in family court could ever make a finding of unfitness. And upon review, they do believe that it can be done in divorce or parentage cases, but, and there's always a but, this finding places that parent one step closer to permanent termination. When that happens, it triggers the protections available in juvenile or adoption cases. An example of one of those protections in today's case is the right to a pleading that puts them on notice and states sufficient facts to allege unfitness. In Illinois, unfitness is found under the Adoption Act. It's kind of a small list of things that can trigger it. Now this is HB 620 and it was assigned to the Family Law and Probate Subcommittee this week. This exact bill was previously an amendment to the original 50/50 bill, HB 185, back in 2019. I covered it in my video about the rise and fall of the Illinois 50/50 movement, but I'm going to follow my sword here just a little bit. I did a pretty poor job reading the amendment. Specifically, I only noted this. Except the amendment got rid of any mention of 50/50 parenting time. You know, the only substantive change that I saw was at scrap factor number 3, when I should have also noted these two other changes. And the reason I skipped over them was because, I erroneously believed unfitness was solely in the realm of juvenile or adoption proceedings and that this proposed language was mostly, fluff. When HB 185 was recycled into HB 620, I took another look, and as I read the holding in today's case, it now appears the bill as written is a colossal train wreck, and the reason why is this key change. Now, it doesn't seem problematic, but that's due in part to a sleight of hand of its purported authors, Illinois Fathers for Equality. To kind of see what's really going on, you have to look at what happens when we take the negative implication of this proposed amendment. Namely, unfit parents do not act in the best interests of their children. So why is that a problem? Well, if a judge says, hey, I don't think you can pick the healthcare providers or the school district or whatever, isn't that the same as the court declaring the parent is not fit to make those decisions? Well, here's the legal problem. In Illinois, unfitness has a legal meaning beyond the other parent can do better. It means things are so bad, the judge feels you can't be trusted with a pet rock. And it's a forever thing in the context of a termination of parental rights trial. In those cases, if you're found unfit and lose your rights because, let's say, you're a junkie, getting clean the next day and coming back to the judge to ask for a do-over isn't possible. It is forever terminated. Done and done. And that is radically different than in family court, where if you did get yourself cleaned up and you come back to the judge and he's convinced you've cleaned up, you would resume parenting time. And this distinction is crucial in understanding the dangers in placing fitness in parentage or divorce court. Because when unfitness is brought into the mix, the stakes get a lot higher. And when that happens, the law requires that if the parent can't afford a lawyer, and this is absolutely crucial here, the taxpayer has to pay for it. And I don't see how you dance around that mandatory taxpayer appointment of counsel under HB 620 once it links fitness with decision making. And I base this off the clear holding from today's case, and here it is one more time. So if mom or dad can't agree on the dentist or the school or the pickup or drop off time, or whether the kids should be vegetarian, have a cell phone, whether the new boyfriend can watch the kids while mom's on vacation in Hawaii, or whatever, HB 620 as written likely triggers that everybody gets a free lawyer, if they can't afford one, on your dime to litigate as long and as often as they feel appropriate. This protection also applies to appeals. Now, typically OSAD, that's the Office of the State Appellate Defender, handles those, but as of recent, the CBA started a pilot program to outsource OSAD's overwhelmed appellate docket, and they've already been doing this for trial matters for a number of years, and trust me, their docket right now is pretty much overwhelmed. So they're sending this out to private lawyers, and it's done on your dime in accordance with Rule 299 of the Illinois Supreme Court rules. And in case you're curious, Rule 299 allows up to $5,000 per case, but not really, because on good cause shown, a private lawyer can come before a judge and ask for more if they feel they've earned it. So this bill as written appears problematic. When people catch a case, it's because the state's attorney chooses to initiate it. Under HB 620, either parent gets to choose when or how often or however or whenever they want to file something. And if they're poor, the appointment of counsel for them is cheap as free. The sky's the limit, if you will. With mandatory appointment of counsel and payment of counsel for all those cases, Illinois Fathers for Equality, who have been longtime critics of the ISBA, they kind of would be gift wrapping us with the biggest bailout in the history of civil litigation, as it would likely create the need to hire more judges, courtrooms, and staff to handle the inevitable influx. And when things like that happen in Illinois, this inevitably happens as well. If you're asking what Illinois Fathers for Equality were thinking when they wrote this, I don't have an answer. But I have to imagine that if I'm the ISBA reading this bill, my first and only thought's going to be this:
I win again, just like always.
Either way, once again, that appears to be the story of that.